Okay. So good morning, everybody. I'm Angela Armstrong, the Executive Director of the Bar Association. I want to welcome you to today's edition of Bar Talk. We have three wonderful guests. I will let Stacy introduce them in a moment. I do want to go over just a little bit of housekeeping / updates that we have. The 2023 Law Day contest for Maine students is going on right now. If you know of any kids, grandkids that would be eligible to participate in that, we ask that you let them know about it. Also, our summer bar conference this year is June 26th through 28th. That is not a typo. It is a Monday through a Wednesday in Bar Harbor. So more information will be coming out about that, but I would love for you to save the dates on your calendar. If you missed it, Chief Justice Valerie Stanfield gave her State of the Judiciary address on March 23rd. I have links on the slide, which will be posted to our website after this closes, and you can either read the remarks or watch the video. And finally, if you haven't heard, the York Judicial Center is just about ready to go. And so if you have any cases in York County, several of the courts will be closing throughout the month of April, and then they will be held at the new York Judicial Center in Biddeford. Visit the website to make sure you know which days those are closing. That's all I have. I will pass it over to Stacy.
Thank you, Angela. For those of you who don't know me, my name is Stacy Stipem, and I am the current president of the Maine State Bar Association. And it is my privilege to be here today with three outstanding practitioners from the state of Maine. For those of you who were able to join Bar Talk on March 1st, when we interviewed Justice Wathen, Jerry Petroselli, and Jim Tierney, we started this series on the retrospective of the Maine Bar over the last several decades. And we're delighted to have an equally impressive panel today to continue that discussion. I will introduce our panelists, and then I will ask them some questions. And I would encourage any of you who have questions to put those questions into the chat feature. Angela will read those. It will only be so long before people get tired of me asking questions, and would welcome the opportunity to have you ask the questions through Angela. So please put any questions you have in the chat feature. We will get to those. Without further ado, let me introduce our panelists today, starting with Judge Jessie Gunther. Judge Gunther was sworn into the bench in January of 1976 as the youngest judge in Maine history. She was 28 years old at the time. She was the second woman to become a judge in Maine. The first, for local historians of interest, was Judge Harriet Henry, who was appointed in 1973 as a judge at large for the Maine District Court. On April 11, 1980, on the appointment of Governor Joseph Brennan, Judge Gunther was sworn in as the first woman on Maine's Superior Court. In 1986, following the birth of her first daughter, she resigned from the bench, but in 1990, she was renominated to the same District 13 bench where her judicial career began. From 1998 until her retirement in 2012, Judge Gunther sat in the District Court in Bangor. Also like to welcome Ginger Davis. After graduating from law school, Ginger clerked for Justice Hall on the New Jersey Supreme Court. Then she went to work for New Jersey's largest law firm, where, in her own words, she had the fun of being the first female pregnant attorney. I guess the first pregnant attorney. She was assigned to the Trust and Estates Group because it was a, quote, safe place for a woman to practice. She worked at AT&T before the breakup for about 6 months, then moved to Maine in 1977. From there, her career progressed at Harold Dana, the Natural Resources Council of Maine, as general counsel for the Maine State Housing Authority, and finally, Ginger capped her career with 25 years at Freddie Flaherty, where she was the first female equity partner. She has served as past president of the MSBA and the New England Bar Association, and is now enjoying a well-earned retirement. And finally, last but certainly not least, Margaret McGaughey. Margaret began her career in the appeals division of the Massachusetts Defenders Committee, at the time the Public Defender Organization for Massachusetts. She then clerked for Frank Coffin of the U.S. Court of Appeals for the First Circuit. In 1978, George Mitchell hired her as an assistant U.S. attorney. As appellate chief of that office, she argued 450 appeals in the United States Courts of Appeal for the First Circuit. Since she retired in 2008, Margaret has taught appellate advocacy remotely and in person at law schools around the country, including at Yale and her alma mater, UPenn, and for law firms and bar associations. Margaret has 3 grown children and 7 not so grown grandchildren. So we welcome all 3 of these amazing women to join us today. And just to get the ball rolling, I'm going to throw out the first question, and I will keep Margaret on the hot seat and direct the first question to you, Margaret. I would love to hear about an experience in your first year or 2 of legal practice that might illustrate how the legal profession has changed over the years.
When I started practicing law, Stacy, the women in the bar were very small. I spent most of my career in appellate courtrooms, which may explain why my experience has been so good. But I was very often the only woman in the courtroom. And I found that to be an advantage because I was a bit of a novelty. I sounded different, I looked different, and the effect of it was that the judges paid attention to my argument, which is what lawyers want. As my career progressed, more and more women began practicing law. And in my experience, what happened was that the judges paid no attention to their gender. They paid attention to whether the lawyers did good work or not. So that's how I see the profession as having evolved.
Thank you, Margaret. That was a great opener for us. Your comments about how you were somewhat of a novelty in the beginning, and then as you noted, more and more women joined the profession as you went on. My next question will be for Ginger Davis. Ginger, how have you seen the profession from your experience largely in a big firm adapt to women entering the practice in significant numbers?
Well, when I started out at Pitney Hardin in New Jersey, and I was the first woman to get pregnant, the men wouldn't get in an elevator with me after I was about 5 months pregnant. I think that has changed dramatically, but I still think women have a ways to go in the profession. I still think there's some kind of, I don't know, maybe it's a cultural bias that hopefully will change. But for example, 55% of law students are women. Only 38% of the profession is women. And there's still some significant discrepancies in the number of equity partners who are women. It's now around 22%. A decade ago, it was 16%. So we're slowly making progress. But I think we have a ways to go. And it was very common for me to be the only woman in the room, which sometimes was interesting. I liked it when there were 2 women in the room, because a lot of times a woman would say something and it would drop on the table, and about 45 minutes later, some guy would say the same thing, and everybody would go, "That's a brilliant idea." And the 2 women would look at each other and go, didn't you say that 45 minutes ago? So I don't know if that still happens, but there have been changes, but women still have a long way to go.
Thank you, Ginger. I'd like to ask a question of Judge Gunther now. Judge Gunther, you have a very extensive career in the courts from the late 1970s to the early 2010s. I'd love to hear from you how you see the court system as having changed over the course of your career. I mean, it can be from the perspective of how it treats based on gender, but also just any changes that you've noticed over the course of your extensive career.
And I assume you don't want me to take the last 50 minutes to cover this, but
take as much time as you want.
No, that's okay. When I started out, there was no court administration. And there was a real intertwining of lawyers, prosecutors, and the court. The clerks of court, at least in Piscataquis and Penobscot counties, typed the complaints. The DAs would tell them who was charged with what. Of course, you had to get the prisoners to the courthouse. If they were bailed to the next court day. Everything, moved kind of faster. The DAs essentially ran the criminal docket. They knew the cases that were ready. They put it together. I assume they had some contact with the clerks, and we knew who was in jail because jail had to go first. But there was a real intertwining of roles. And I think it was purposeful that court administration came to separate us. The DAs went first. They, in 77, 76, 77, DA's offices were created in the 8 districts, and they took over writing the complaints and doing that sort of thing. The defense lawyers, as you know, that's been an on-running thing. The defense lawyers were paid from the court's budget. And although this may not be widely known, at least from judges' meetings, one of the reasons, forget the good stuff about better quality, blah, 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 blah. One of the reasons to move the court-appointed lawyers out of the court was because of the budgetary. That way, the legislature would have to take over paying for them, and it wouldn't be a subset of the court budget. Court administration has taken off. Those of us on the righter wing politically think that we have way too much administration overall, but whether that's true in the court system or not, I don't know. I've been gone 10 years. The people who work there have always been dedicated and I think efficient. I'm not sure computers add a great deal, but there you are. The other big change has been self-represented litigants, which is, back when I started, if you had a court case, you had a lawyer. You didn't figure you could pick up the paperwork from the clerk and go it on your own. In terms of public service, it's easier to get into court, but I sense that many of them are floundering once they get there. And I wish we could go back to having more lawyers for the litigants. So far that I'll stop there.
It's interesting, and just a quick follow-up. Do you think the decline in, or the increase in the number of self-represented litigants that you saw towards the end of your career was a result of the decline of the number of lawyers around to take the cases, or some other reason?
Oh, I think it's some other. I think there has been a popularization of the idea that a lot of this stuff you can handle yourself. You're just throwing your money away on the lawyer. And we've sort of fed into that by, deed forms, will forms, complaint forms, small claims increase the limit, that sort of thing.
Well, thank you, Judge Gunther. My next question is sort of more of a holistic one. I'm curious as to what the most significant changes to the profession as a whole that you've seen over the course of your career. And I'll just go back to Margaret, she hasn't been on the hot seat for a while, but what are the most significant changes to the profession you've seen? And then I'm going to ask our other panelists as well.
I think one of the most significant changes is not for the better, and it is a decline in civility in the practice of law. When I started out, I was admitted to the bar in 1978, and my bar number is 1,442. I recently helped a young lawyer do an appeal. His bar number is 1,100,000. Now, obviously, not all of those lawyers are still practicing or even still alive, but when I started, all of the women in Southern Maine got together for lunch periodically. Lawyers were small enough in numbers that we all knew we were rubbing elbows with each other. And so it was in our enlightened self-interest to be civil to each other. So if someone called me up and said, will you assent to an extension? I'd say, sure, because I knew that the next person who might need an extension would be me. And what I think now is that the numbers of lawyers have become so large that we're not rubbing elbows with each other regularly. And it's become much more of a game of gotcha. I also think that what has contributed to the decline in civility in some ways is the increased formality, at least in federal litigation. I started out my career doing both appellate work and trial work. And a lot of the trial work took place in the judge's chambers. The judge would be sitting behind his desk, his robe would be off, the lawyers would be in chairs around him, somebody would bring in coffee, inevitably somebody would crack a joke, and it created a very congenial atmosphere that allowed people to work together. I think that's gone. I also think there's just generally a decline in manners. The practice when I started in the First Circuit Court of Appeals was that when you finished an argument, you went over to counsel table and you shook the other lawyer's hand. By the time I left in 2017, that wasn't happening anymore. And I think it's too bad.
Thank you, Margaret. I'd be interested in Judge Gunther, view from the bench. Did you notice a decline in civility as well over the course of your career? I understand everyone's always polite to you as the judge, but just what were your general observations?
Well, certainly I noticed the change from, everybody getting together and kind of chatting like Margaret was describing, that went away. And let me just put in a plug for poor Judge Martin. That recent court reversal of his was not, that would have never come up or been of concern way back when. But if the focus back when I started, the bar set fees for various things, and there wasn't quite the focus. Now, I know that Dan Wathen, my former boss, just pulled his hair out sometimes because we didn't care enough about money, but there wasn't necessarily the focus on advertising, earning money. Well, you couldn't advertise, that sort of thing. And I think that the fight for the dollar is a factor in the lack of civility. Because you want the money, you don't want to share it.
And last but not least, welcome, Ginger, if you have anything to comment on about the significant changes to the profession that you've seen over the course of your career. Oh, Ginger, I think you're on mute.
I don't see your picture anymore.
I agree with Judge Gunther that I think the part of the lack of civility comes from the fact that now it seems to me that law is more of a business than a profession. When I started, it was more of a profession, and it was less emphasis on being a business. And I think certainly the pressure to win, because it's good for you and it's good for your firm as well as for your client, and certainly the pressure to put in the billable hours and get the result for the client. I think that really contributes to the lack of civility. I also think that there's a pressure that lawyers used to be counselors. We were counselors at law. And if a client came in with a case that didn't really seem like it was going to go anywhere, or that it was going to be good for their business in the long run, lawyers would advise them of that. I don't see that happening now. I think lawyers are concerned that if they say, this really isn't a good idea, and your chance of success isn't really that great, they're concerned that the client will just go to another law firm, and the other law firm will say, sure, we'll do that for you. So yes, there is a lack of civility. And when I started in Maine, this didn't happen in New Jersey, but when I started in Maine, lawyers refer to each other generally as my brother at the bar. And as soon as you show up and they start talking about my brother at the bar, they look at you and it would flummox them. That was kind of fun.
Excellent. So they didn't refer to you as my sister at the bar?
No, never.
No, okay. Just a follow-up question for you, Ginger, on this important topic that you've raised. Do you think that there has been a shift in the way the public has viewed the legal profession? So Judge Gunther, I know, mentioned that there seemed to be a rise in people who thought that they could do this themselves without a lawyer for at least certain types of cases. Have you noticed a shift, not just how the profession views itself, but how the public views the legal profession?
Absolutely. And part of it, my dad was a lawyer, and I had a good friend whose father was a doctor. And it used to be that lawyers and doctors would get paid by a client who couldn't afford to write a check or give them cash. It was before credit cards. They would show up with a pot roast or a dozen eggs or something. It was more of a, almost more like a barter system. And so I think there was more respect for lawyers who would help you even if you couldn't pay. And I think that's gone. I think because of the fact that we've become a business, there is a concern that lawyers don't care for the little guy who can't pay.
I do remember one time my father brought home a kayak. So a client had paid him by making him a kayak. I'm not sure he ever used it, but it sat in our garage proudly for a number of years. Margaret, I'd be interested in your views about Ginger's comment.
Well, in terms of the public perception, I spent my career as a prosecutor, and I think increasingly prosecutors are getting a bum rap, and it's partly the defund the police notion. I know that in a lot of law schools, prosecutors are viewed as evil. And I think that's a misperception. Prosecutors do have a fair amount of power, but we want well-educated, well-meaning people to do it because they make charging decisions. They make sentencing recommendations. And that doesn't mean that they're evil, that they're doing it. They're in some ways protecting victims. And I think that gets lost in the public perception of prosecutors. I think they're more likely to be viewed as the bad guy who is putting an innocent guy in jail.
So we've talked a little bit about the decline of civility and sort of other negative changes in the profession over the past few decades. I'd be interested, what's one aspect of the legal profession today you think is an improvement over past practice? And Margaret, I'll just keep you on the hot seat. Anything that comes to mind?
Sure. Paternity leave. When I had my 3 children, there wasn't any. And now I think it's a common practice in most law firms.
And Ginger, what about you?
Well, I think paternity leave is a good thing. I think that just having more women in the profession is a very good thing. I'm not sure. I think when you talk about kids, I think having kids is still a hurdle for women, and part of it is systemic. I reread something that Anne-Marie Slaughter wrote a decade ago, and I think it's still difficult for women because childcare is still a very difficult issue.
So I want to come back to that issue of juggling work and parenthood. But before I do, Judge Gunther, any thoughts you have about what is one aspect of the legal profession in the last 10 years or so that you think is an improvement over past practice?
Sort of a follow-up to what Ginger just said is that when I started, paternity cases were called F&B, which is fornication and bastardy. And that was the way there wasn't any sense of justice being 2 people who are parents of a child who are unable to resolve their issues about money and interaction. Now, I think we've gotten, this is not necessarily better at being sensitive to the issues that are involved in parental rights cases. And also recognize, I think we are more sensitive to fathers' rights than we used to be, but I think there is still a cadre of people out there who think that all of us on the bench are determined to get the kids and the money to the mother whenever there's a fight. I think the family court system has some advantages that we did not have back in the days when, well, it was so long ago that we didn't even have marital property. So I think there's been improvement in the way we look at families. Unfortunately, over this time, families have been disintegrating beyond our estimate and beyond our ability to keep up with them. So that's too bad.
I'd like to do a follow-up, maybe from a personal perspective, if you're willing to share. All three of you had sort of very impressive careers and also are parents. And as you mentioned, parental leave was something that wasn't particularly common in the 1980s or before or a little bit after. How did you find juggling work and parenthood at a time when the profession didn't exactly make accommodations for working mothers? Gunther, are you willing to share that?
Sure. When I was pregnant with my first child, I was the first associate to be pregnant. They had no maternity policy. They had no idea what to do with me. And it was not fun to be the trailblazer. It was not fun to have guys say, uh-oh, I don't want to get in the elevator with you because if we get stuck, I don't want to have to deliver the baby. No, I was only 5 months pregnant. I am an identical twin, and I did kind of get back to them because when I was past my due date, I got assigned to cases. When I was about 5 months pregnant, I got assigned to cases that it wouldn't make any difference if I dropped off the team. So I was in a meeting with like 12 other lawyers, and I was the only woman. And I had lunch with my identical twin, who was not pregnant. And I sent her up to the conference room. I drew a little map of where the conference room was, who was around the table. She went up 20 minutes after we were supposed to be back and walked in the door looking totally non-pregnant. She runs every day. And she said, well, it's a boy. Half of them fell on the floor. I think maternity policies have changed for the better. I still think it's a problem for men who are very reluctant to take maternity leave or paternity leave because of the view that it jeopardizes their career. And I think now, gosh, my daughter had 6 months maternity leave. I had 6 weeks finally with my last kid. But it's just very different. And when the kids were little, I never felt like I went to the office without oatmeal somewhere on me or scrambled eggs. And I don't know about my male counterparts, but long about 5 or 5:30, I would feel this huge pressure that I had to get home and get to the kids and do something for the kids. I also think that now there are accommodations for women who want to breastfeed their kids. There was nothing like that when I started. And I still found, even when I was close to retirement, that if a woman took time off to take her kid to the pediatrician or to go to a soccer game, we weren't serious about our careers. But if a guy did it, they were a hero. So it is very hard. I love being a mom. I found it very hard to be a working mom in a law firm with 3 little kids, even 3 high school kids.
Well, I think it will be hard to ever top on any bar talk, the discussion, the story about you and your identical twin. I think that might be a bar talk high. So thank you for sharing that story and your comments as well. Margaret, were things any different for you not being in a private firm, being in the public sector?
Well, in terms of maternity leave, I was allowed to use all of my sick leave and all of my vacation leave as maternity leave. There wasn't a formal maternity leave at the time. So I spaced my children so that I had enough vacation and sick leave to have 4 months off with each of them. I really lucked out in terms of the home life balance. Part of the reason I lucked out is because when I joined the U.S. Attorney's Office, I did a kind of work that nobody else wanted to do, and that was appellate work. Appellate work is much more conducive to home life balance than is a litigation. You can sit in the bleachers at a swim meet, look up when your child is swimming their event, and go back to editing a brief until your child's next event is up. The second way I really lucked out is that I was able to work 3 days a week. And I don't think any of the judges ever knew that I worked 3 days a week. I never heard my bosses complain that I wasn't carrying my fair share of the work. And I never heard my children complain that I didn't spend enough time with them. So for me, the 3-day work week allowed me to be the kind of lawyer I wanted to be, but also the kind of mother I wanted to be.
Thank you, Margaret. And Judge Gunther, obviously you were confronted with a fairly rigid schedule of being on the bench. And I understand you ended up resigning from the bench and then going back. Are you willing to share a little bit about the decision behind that?
There wasn't a great deal of thought went into it. I knew that I wanted to be home with the girls, well, one girl. And when the opening came up to go back on the bench, which I believe was after, I think it was after Judge Calkins moved on to Portland to be chief judge. When that opportunity came up, my husband and I discussed it, and he decided he volunteered. A really good father. He stayed home with the girl, both girls. I had both by then, so that worked out. And he is a great parent, so he took care of all the caretaking that I couldn't do while I was roaming around the bench, and that it worked out well for both of us.
So a lot of variety, a lot of differences in how you juggled two very important aspects of your life. Thank you for sharing those stories. Angela, why don't we take a break from me asking questions, and if you have a question or two from the audience, perhaps you could share them.
I have a question specifically for Judge Gunther because it's about being a judge. What advice do you have for early or mid-career attorneys interested in becoming a judge in the future? Which networking, volunteer, or career opportunities do you recommend for those interested in a future career as a judge?
I don't know. Things have changed so much. I mean, I did benefit for being one of few visible women at the time I was appointed by Governor Longley way back when. That was not a time when you had to apply to be a judge. I'm sure there were ways to convey your interest, but basically the system worked very differently. Now there is an application process. I don't think it matters a great deal. I think it helps to be visible within trials, but we see many people or some people appointed from non-trial backgrounds. And I think it is important, it can be important to demonstrate that you have some ability to think and write. You advertised the law day essays earlier on. I reviewed a few of those, and it was scary how illiterate they are. And so if you can submit something to the Bar Journal or to something else that shows that you can think and write at the same time, I think that's a tremendous advantage. And do things that, you know, basically behave yourself.
Thank you, Judge. So I have one kind of additional question to ask folks, and then we can see if there's any other questions that come in through the chat feature. And I'll have, I guess I'll turn to Ginger to get us started with this one. Do you think, we've talked a lot about sort of how the profession has changed, both the decline of civility, the increase in the number of women, there's leave policies, things like that. Do you think additional strides need to be taken to ensure the fair and full participation of women in the legal profession? And if so, what do you recommend?
Yes, I think more strides need to be made. It's hard to say, Stacey. One thing to pick up on what Margaret said, she only worked 3 days a week. At one point, I job shared with another woman attorney. She worked 2 days a week. We were working on a very big litigation, many parties. I think I went Monday, Wednesday, and Friday. She went Tuesdays and Thursdays. And generally at the end of each day of litigation, we would consult with each other. And we had a very focused, but it was not a huge part of the case, but to us it was very significant. And we stayed on our focus and we talked to each other. So there was never any, the right hand didn't know what the left hand was doing, or one of us would repeat the other one in the proceedings the next day. And if it was something that was really important to our issues, we would generally both go if we could. And what I found interesting was after, it was a hearing examiner, and after the proceeding was over, the hearing examiner came up to us and complimented us and said, you know, I wasn't sure how this was going to work, but you guys were always focused, and you were one of the handful of litigants that stayed focused on the issues that you were concerned about and didn't get into extraneous stuff. So I'm not sure why more people don't explore the idea of job sharing. I also think that as more and more men get involved in parenting, hopefully the stigma, if you will, that attaches to men, I think more so than women who take time off to be parenting, I hope that that goes away, except for my example, like if a guy goes to a kid's soccer game, he's a hero. If I went to a kid's soccer game, I wasn't serious about my profession. And I think particularly if, I don't know if it makes a difference if the woman is the sole breadwinner or the principal breadwinner, but my husband is also a lawyer and we both happen to practice in the same firm. I think there was some resentment that that I was taking time off. My husband didn't. I was taking time off to go to the kids' soccer games, but it was important to me.
Thank you, Ginger. Either Margaret or Judge Gunther, any views from coming at it from the public sector and not a background in the public sector and not from a firm?
I'll take that one. I think enormous strides have been made. We had our first female U.S. attorney in Paula Silsby now 10 years ago. We currently have a female U.S. attorney in the 5 districts in the First Circuit. The appellate chief in 3 of them is a woman. I think maybe this is the difference between the public sector and the private sector, but I think there has been a great deal of progress. And as the numbers even out, I think there will be even more progress.
Can I do a different angle, Stacy?
Absolutely.
Okay, I just want to shout out the poor people in the clerk's office who are largely female. And I think that those of us who do trial work know that it's probably more important to stay on the right side of the clerk than the judge. Now, one of the sad things that's happened that I think is hard on the clerks is things that the administration has introduced about degrees and this and that and sort of thing. And you actually are pushing really competent women out of the clerk's office because they don't have the credentials. And this, I think, is a problem. I don't know, but I think that those are the women who do it. They're mostly women. I know we have a male clerk in Bangor, and we used to have a super clerk up in Aroostook, Bob Rush, but they're doing a lot of work. They aren't getting a great deal of appreciation in the area where civility has declined. A lot of it has declined in the way the clerk's office is treated. And I don't know what we do about that, but maybe if we at least validate the job that the clerks are doing in largely female offices, that'll help with women everywhere.
If I could just follow through on that, one of the best pieces of advice my first boss gave me was that there are two people in the practice of law you can never afford to intimidate or not get along with. One of them is the clerk, and the other one is your assistant, because if either one decides to sandbag you, you're done.
That is very sound advice for both of you. So we have one question that comes in from the chat, and I think it's a great question for us to end our conversation on. And it is, you all three of you have had lengthy and storied careers. If you had to name something in your career you are most proud of as a professional accomplishment, what would it be?
Well, I'll jump in. Way back when I was representing the Natural Resources Council of Maine, when I came in, there was a huge case that had been going on forever. And it was Pittston wanted to build an oil refinery in Eastport. And I decided that there was more than one way to skin the cat. And fortunately, there was a large group, or relatively large group, of citizens in Eastport who thought the idea of a refinery there was ridiculous. And to some extent it was, because the super tankers would have to go through Head Harbor Passage, which has notoriously bad currents and winds. And if a super tanker got into trouble in the Head Harbor Passage, it would have its bow on one end and its stern on the other end, totally blocking the passage and probably in major distress. I decided, and so there were all kinds of environmental and economic issues being bandied about. It had been, I think it had been up to the First Circuit at least once already, and I decided there was a better way to get rid of the case. So I started working with the people who lived in Eastport to get rid of the project. And it turned out that it turned out that the land that was required to build the deep port for the tankers to come in at was owned by the town. And the town had given a lease to Pittston. And so I started working with the project opponents in town, and I started talking to the city council. And I remember the city council was going to be having a meeting about whether or not they should renew the lease. And I remember talking to the chairman of the council, I think the day before, and needless to say, Pittston was rattling a tin cup on the bars all the time, saying, well, if you don't renew the lease, we're going to sue you and you'll be in major league trouble. So I remember calling up this guy, Fred Stotterstrom, and saying, so Fred, guess what? You can't win on not being sued, because if you renew the lease, you're going to be sued by the project opponents. If you don't renew the lease, you're probably going to be sued by Pittston. Either way, you're going to be sued. So just do the right thing. And all the local opponents were all hyped up, and they had the council meeting in the high school gym. And so I remember sitting in the high school gym with a bunch of the project opponents. And I think there were 7 council members. And it started off, and the first one said, well, I'm not going to vote to sign the lease, and explained why. And then it went on down the line. The first 6, including the council chair, said, we're not voting to extend the lease. And it got to the last guy who said, well, I would really like to see this project go forward, but I'm not going to do a useless act. So I refuse to sign the lease. The lease was not extended. The project died. It was wonderful. Sorry, Margaret, we didn't have to go to the First Circuit.
It's a good story, although not as good as your twins, Andrew. But no, congratulations on that, Margaret. What comes to mind for you?
Probably the most satisfying cases I did were where I was representing the United States, not as the appellee, but as the appellant. And those were satisfying because of the multiple layers of review I had to get from the Department of Justice or the Solicitor General's office, even to go forward. And when I succeeded in reversing a trial judge as good as our federal trial judges were, it was extremely satisfying.
Well, Judge Gunther, I'm sure you never were reversed because you were, I'm sure, infallible on the bench. But what would you say your best professional accomplishment would be? Something that you're proudest of?
Actually, nothing comes to mind. And it may be a function of my personality, but I can remember the disasters. I don't necessarily remember the successes. You can say that I tried an arson case in Lincoln County once, and the guy was found not guilty. And that was a lucky thing for me because I've never screwed up a trial as badly. But as you know, nobody can appeal a not guilty finding. I did, for what, I don't remember anything about Ginger. I don't remember anything. I did have the Pittston Airport case, but I don't remember anything. That was an ADB appeal someplace along the line. I will, however, since I have the podium, say that the worst thing that's happened to the judicial system is the summary judgment rule. We aren't having enough trials. We don't have enough lawyers getting cases to try. It's all become, or at least when I left, it was a game of gotcha on who put the best statement together as opposed to anything else. And if I could do one thing, it would be repeal the summary judgment rule. That's it for me.
Well, we have heard that certainly there's a lot fewer trials and a lot less trial experience for practitioners today than practitioners several years ago. So that is certainly a fair observation. All right, I think with that, we're going to close. Thank you all so much for participating in this month's Bar Talk. I think this has been a fascinating discussion, and I now know what F and B stands for. Which is something I did not know before this Zoom call. So thank you again for the 3 of you for sharing your observations and your wealth of experience with us.
You're welcome.
Thank you.
Welcome.